Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of service law, especially matters involving the courts to refrain from interfering with findings of facts recorded in a departmental inquiry. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Union of India and Others versus SUBRATA NATH pronounced on 23rd November 2022, disciplinary proceedings against respondent constable resulted in an order of his dismissal from service. The appellate and the revisional authorities upheld the said order. The respondent filed a writ petition before Calcutta High Court. The single judge set aside the punishment of dismissal and compulsorily retired respondent from service along with all consequential benefits. On appeals, the division bench reinstated the respondent along with full back wages. The disciplinary authority was further directed to issue a fresh order of punishment that should consummate to his negligence and dereliction of duty other than a punishment of dismissal, a removal from service or compulsory retirement. Being aggrieved, the present appeals have been filed with allegation that the High Court acted as appellate authority by directing a reinstatement of the respondent, which runs contrary to the law laid down in B.C. Sadurvedi versus Union of India and Others, reported in 1995, 6 SCC 749. The point that arises for consideration is whether single judge and the division bench ought to have interfered with the punishment imposed on respondent by the disciplinary authority and upheld by the appellate and the revisional authorities. The Supreme Court has held that courts ought to refrain from interfering with findings of facts recorded in a departmental inquiry, except in circumstances where such findings are patently perverse or grossly incompatible with the evidence on record. However, if principles of natural justice have been violated, or the statutory regulations have not been adhered to, or there are malefides attributable to the disciplinary authority, then the courts can certainly interfere. Being fact-finding authorities, both the disciplinary and the appellate authorities are vested with the exclusive power to examine the evidence forming part of the inquiry report. On finding the evidence to be adequate and reliable during the departmental inquiry, the disciplinary authority has the discretion to impose appropriate punishment on the delinquent employee, keeping in mind the gravity of the misconduct. However, in exercise of powers of judicial review, the High Court, or for that matter, the tribunal, cannot ordinarily reappreciate the evidence to arrive at its own conclusion in respect of the penalty imposed, unless and until the punishment imposed is so disproportionate to the offense that it would shock the conscience of the High Court or tribunal, or is found to be flawed for other reasons. The records reveal that the disciplinary authority minutely examined the entire evidence brought on record, including the deposition of 8 prosecution witnesses, each of whom corroborated the charges leveled against the respondent, duly supported by documentary and circumstantial evidence, for arriving at the conclusion that the articles of charge 1 stood proved against the respondent. Pertinently, the respondent did not produce any defense witness, and the documents produced by him did not prove anything in his favor. As for charge 2, the disciplinary authority noted the statement of PW4, who was working as in charge of the document section of the unit and was summoned to prove copies of the service documents related to the respondent, and on going through the said documentary evidence, noted that the respondent was awarded 8 punishments over a period of 13 years of service for various delinquencies, but he did not reform himself. In view of his continuous misconduct in the past, coupled with the serious offense of theft of 800 kilograms of copper wires, subject matter of charge 1, the disciplinary authority opined that the respondent was unfit to be retained in a disciplined force and therefore directed his dismissal. The findings of the disciplinary authority met with the approval of the appellate authority and the revisional authority. However, the single judge overturned the dismissal order and converted the same to compulsory retirement on the sole ground of non-availability of the original record, more specifically the bead book, while giving a go-by to the extract of the bead book that was produced before the inquiry officer and the fact that the respondent admitted this said document. The single judge also ignored the fact that the bead book was not only the piece of document produced before the inquiry officer. There were depositions of other witnesses produced by the department to prove the charges leveled against the respondent, and the said witnesses corroborated the version of the department. At no stage did the single judge observe that the departmental inquiry was vitiated on account of violation of rules of natural justice, or that the inquiry was conducted in gross violation of the statutory rules. The division bench went a step further and proceeded to reappreciate the evidence and observed that it was not persuaded to conclude that such a major theft of 800 kilograms comprising of 42 bundles of copper wires could have happened in the blink of an eyelid, despite holding that the view of the single judge regarding non-production of the original bead book was unsustainable. The court held that the allegation of connivance in the theft leveled against the respondent was presumptive, and there wasn't enough evidence to conclude that theft of such a magnitude could have happened during the duty period of the respondent alone, yet charge one pertaining to negligence and dereliction of duty on the part of the respondent was sustained. At the same time, the order passed by the single judge directing substitution of the punishment of dismissal with that of compulsory retirement was set aside, and the respondent was directed to be reinstated in service with full back wages, while giving liberty to the disciplinary authority to issue a fresh order of punishment commensurate to the negligence and dereliction of duties on his part, except for punishment of dismissal or removal from service or compulsory retirement. There was no good reason for the High Court to have entered the domain of the factual aspects relating to the evidence recorded before the inquiry officer. This was an attempt to reappreciate the evidence, which is impermissible in exercise of powers of judicial review vested under Article 226 of the Constitution. Therefore, the High Court ought not to have interfered with the findings of fact recorded by the disciplinary authority. Thus, the single judge and the division bench erred by setting aside the dismissal order. This court finds in complete agreement with the findings returned by and conclusion arrived at by the disciplinary authority, duly confirmed by the appellate authority and upheld by the revisional authority in respect of both the articles of charges leveled against the respondent and the punishment imposed on him. The respondent, being a member of the disciplined force, was expected to have discharged his duty diligently. Further, the records revealed that the respondent did not mend his ways during 13 years of service rendered by him and was awarded 8 punishments for the various delinquencies, out of which 3 punishments included stoppage of increment on 2 occasions for 1 year without cumulative effect twice, and stoppage of increment for 2 years without cumulative effect on 1 occasion. In such circumstances, the desirability of continuing the respondent in armed forces is questionable, and the disciplinary authority could not be expected to wear blinkers in respect of his past conduct while imposing the penalty of dismissal. Therefore, it is appropriate to quash and set aside the impugned judgments and orders while restoring the findings and the conclusion arrived at by the disciplinary authority, duly upheld by the appellate authority and endorsed by the revisional authority. Thus, the penalty of the dismissal imposed on respondent is commensurate with the gross negligence and dereliction of his duty.